Thank you, Mr. Chair. Thank you, Commissioner. Thank you for being here this morning.
You're welcome.
Thank you. So just for clarification, the process now when an individual has to be moved out of Whiting would be an approval, a recommendation coming from Demas, and the board then looking at that recommendation and going with the recommendation, or obviously objecting in their analysis if they feel that placement, whatever you've requested on behalf of Demas, is inappropriate. So that's the current system that we have.
That's correct.
And your request to us is, if I understand it correctly, is that oversight from the board is not needed, and Demas can then unilaterally decide whether that individual goes to Dutcher, goes to a community, or stays back at Whiting. Is that your recommendation to us?
There are a couple different pieces of this legislation that we support, and again, we didn't propose this legislation. We do support, so if an individual is, we do support being able to be the agency that makes the clinical determination whether an individual is submitted to maximum security, maximum security setting. It may be that Dutcher is the best place for the individual. That is a clinical decision, and so we are in support of that. Being able to do that assessment and evaluation to determine where an individual should be placed.
But where is your assessment being questioned at all? I don't see that as an issue. The issue, as I understand that, is that when your decision is made, that decision has to be, either agreed upon or not agreed upon by the board. And that's where you feel that oversight is not needed.
I'm going to ask Dr. Norco to come up and give some additional detail, because there are some specific nuances about that I think it's important to discuss and to have for the record. Dr. Norco is the director of our Forensic Services Division and also acting director of Whiting Forensic Hospital. And so there's some key nuance in here that I think it's important to sort of lay out some of that detail.
Okay, doctor, for the record, please identify yourself for the record.
Dr. Michael Norco, Director of Forensic Services for Demas and Acting Director of the Whiting Forensic Division of Connecticut Valley Hospital.
Thank you. Please proceed.
As Ellen LaChance was saying, talking about the vetting process that goes on in the hospital, so if I could just take a step back and explain that part of it. When a treatment team believes that the patient that they're treating could be ready for a discharge or transfer to the less secure Dutcher facility, they come to what we refer to as the Division Review Committee, which is the leadership of the division, and they have to present their case. We ask questions, we review the person's treatment history, and then make a decision whether we in the division support it. If we support it in the division, then it goes to a committee that's chaired by the CEO of Connecticut Valley Hospital, which is another group of people, which also involves independent consulting forensic psychiatrists as part of the risk assessment team. And the case has to be presented there again, and the CEO has to make a final decision. In that process, the consulting forensic psychiatrist, who is independent of the hospital, is asked to do a specific independent review, meet with the patient, meet with the treatment team, review the record, and formulate an assessment of what they think the risks are and whether they could be appropriately managed in the Dutcher setting. If they come back and make that recommendation, then usually the CEO will go along with that determination and direct the forensic division to proceed with a recommendation letter to the board. And then it proceeds as you were discussing, that the board makes the decision. So our position on this is that none of all of that vetting would change under this. We would still continue to do all of that careful review. So we don't think it's absolutely necessary to have the board involved, although it's not either absolutely necessary to remove it.
Thank you. And in your experience in the years you've been there, what has been the denial, or what shall I say, when you have approved it, and so has this, the special board that you talked about, and then goes to the final board. I mean, the percentage of the board saying, as I understand it from the previous testimony, is marginal at best.
Right, so the board, as Ms. LaChance testified, approves 95% of our requests. At the hospital level, there are times when it's kind of similar to the answer that Ms. LaChance gave. It's rare that the facility review committee, chaired by the CEO, says no and keeps saying no when the team is saying yes. Most often what happens is the hospital review committee thinks we need a little bit more information about this or about that, or we'd like to see a couple of more months of the patient's stability or lack of assaultiveness before we're willing to recommend, or we really would like to see more psychological testing done, or we'd like to see this person in individual therapy. So usually it's we'd like the team to go back and do something else and then come back to us when you've done that, and we'll reconsider the case. So most of the time, eventually, the hospital does agree with the team. I can't think of a case in which the team kept saying, yes, we think the patient's ready, and the hospital said no. But there are a number of cases where we ask the team to do more work with the patient first.
Thank you. Thank you, Mr. Chair.
Good morning, Senator Doyle, Representative Stastrom, and the other members of the Judiciary Committee. My name is Sabira Gordon, and I'm the Executive Director for the Commission on Equity and Opportunity. I'm here today to speak to you about two bills, Senate Bill 13 and House Bill 5544. Senate Bill 13, I'm not going to read my testimony, you have it in front of you, really deals with the dignity of women who are incarcerated. It looks at treating women in a humane way as they go through the cycles of being a female. I'll just outline a few of the things that the bill does. It prohibits the shackling of pregnant inmates during labor, which we will be probably in the middle of the pack for states that are finally going to do this. This is something that I think is very important for us to do as a state and ensure that women who are giving labor are not shackled to their bed. Just to be clear, this is an administrative practice right now within the DOC, so we're not upsetting the apple cart or anything. The commissioner does support this bill. It requires DOC to provide female inmates with feminine hygiene products at no cost. It requires DOC to establish child-friendly visitation policies. It prohibits non-medical staff of the opposite staff from viewing or interfering with incarcerated women engaged in personal activities such as undressing, using the toilet facilities, or showering. It requires DOC to establish and provide parenting support as well as prenatal and postpartum services and supports. And those are just some of the things that the bill does. I think this is very important in 2018, as this state has been a leader in judicial reform and looking at how we deal with our incarcerated individuals. The Commission on Equity and Opportunity is very interested in this bill because, like many others that deal with the judicial system, there's disproportional minority contact. There are more women of color that are incarcerated than other females, proportionally to the population in the state. And this is very important because I think as women go through, as parents, they have their child and they go through labor, it's very dehumanizing to be shackled to a bed to give labor to that child. So as I said, we have some, the commission does have some suggestions to tighten up this language, and we think it would make it better. I included that in my written testimony. So I also want to speak briefly about House Bill 5544 that changes a misdemeanor maximum sentence from 365 days to 364 days. This is very important, I think, for states' rights. It allows those who go through the judicial system in Connecticut to be treated as a misdemeanor and not classified as an aggravated felony within the federal system, because 365 days could be considered as an aggravated felony for the federal system. So we support that bill because we would like to see Connecticut's residents be treated as such because they go through the judicial system in Connecticut. And I want to thank you for your time today.
Thank you, Ms. Gordon. Any questions for Ms. Gordon? Dr. Srinivasan.
Thank you, Mr. Chair. Thank you for coming here this morning to testimony. If your requests, on the of things that need to be done so that we treat our women who are incarcerated in a dignified way, which obviously we all are on the same page on that. There's no question about that at all. But if the commissioner is also in agreement, which is what you just mentioned, if I heard you correctly, then do you need this to go through a legislative process, or it is just something that can be worked out?
Well, the commissioner who is there now will not be the commissioner for the forever. So I think because we have a commissioner that has shown a level of commitment to this, I think it's very important. As I said, many other states, over 20, I think over 25 other states do this. So I am not necessarily sure that the next commissioner who is going to come in is going to agree with the administrative policies of the present commissioner. So I think it's really important that we have this stuff in statute, and it shows that Connecticut is committed to the humane treatment of women. I think that if we make it a state law.